Just to give you an example, you know the Coca-Cola company, they obviously have a trademark, a registered trademark, I'm sure, over the words Coca-Cola. And if somebody registered the domain name coca-coladrinks.com, I think you would agree with me that was similar to Coca-Cola and confusingly similar, because people looking at the domain name Coca-Cola Drinks would of course assume that it's official Coca-Cola and not just some fanciful pretense that the domain name holder has drummed up. So let's say that you've got to the first stage and you have been able to show to the arbitrator that the domain name you are in dispute about is similar to your trademark and potentially confusing to people. What is the second step that must be proved in your case? The second step you will have to prove is that the person who has registered the domain name has no right to it at all, none at all. They have to show themselves that they have a right to use the domain name and that it represents a legitimate business or personal interest of theirs to justify having the domain name at all. Now, let me give you some examples of how they may be able to show that they have a right to the domain name or an interest in it. Say if, for instance, before the dispute arose, they were using the domain name for a legitimate business. There was no hanky-panky about it. It was just in the normal course of business. They were using the domain name above board and legitimately to sell their goods or run their business. And they were doing that not to get at you, but simply because that was the name they wanted in their domain name, and they were running a business using that domain name before you started your complaint against them. If they succeeded in establishing that, then they have got a right or a legitimate interest in the domain name. A second example might be that if they registered the domain name in their own name, if the domain name was their own name, the name by which they are known, and they were going to use the domain name, for instance, for a family website, for travelogues and photos of the family as the children grew up, then that would give them a right or a legitimate interest to have the domain name. There are lots of other ways they can show that, but I think the examples that I have given you will give you the general picture. So that's the second thing that you have to prove. Just to go over that again very briefly, you have to prove that the person who has registered the domain name has a legitimate interest in having it and using it. Okay, now the third and final thing that you must prove if you want to succeed in this case is a very important requirement. That requirement is you have to show that the person who registered the domain name and who is using it has done so in bad faith. In bad faith. In other words, it's not just any old domain name you can claim back. You have to prove that they really have had you in the gun and they have been activated by bad motives towards you, and that is the reason why they have registered the domain name. Again, let me give you an example. Say if they registered a domain name and it was very similar to your business name, and they used the domain name for a website that was advertising the same goods and services as your business does. Well, that is probably bad faith, because they are trying to trick people into thinking that their website is your website and their goods and services, whether they're in competition with yours or not, that they're trying to convince people that either they really are you or their business is your business, or they're trying to deceive and mislead people. And that really is the essence of bad faith. It's a bad motive. So in other words, it's not just that they have registered a domain name and not just that it's inconvenient for you, but they really are using it because they have bad intentions directed to you, the trademark owner. So they are the three elements in this arbitration process that have to be established. To go over it again very briefly, you have to show the domain name that you want is similar and confusingly similar to your trademark. Secondly, you have to show the person who has registered the domain name has no right to do so. And thirdly, you have to show that in registering the domain name and in using it, they have been motivated by bad faith. Now, all of what I've been saying today is about the big league of domain names, .com, .info, .biz, all of those, the major domain names. As you know, there are also domain names which are with a country call sign. For instance, you have often seen, I'm sure, the Australian domain names that end in .com, .au. You have probably also seen domain names in the United Kingdom which are .co, C-O, that is, .co.uk. So each country has its own subgroup of domain names, and you can use the arbitration process for those domain names as well. But a big cautionary note, if you are going to do that, make sure that the scheme under which you are going to go to arbitration is the same as the one for the big league of .com that I've been talking about today. That is called the Uniform Domain Name Dispute Resolution Process, and the different processes for different individual countries. If you're after an Australian domain name or a UK domain name or a United States domain name, they have different dispute resolution policies, so just be careful of that. Now, I think that's a fairly clear, or I hope it's a clear statement of the basic principles. What you actually do is this: you have to go to one of the providers of arbitration services who will let you lodge the claim with them for a fairly modest fee compared with court proceedings. There are two major bodies that do these claims, and you should approach them if you want to bring a domain name claim in the .com league. The first of them is WIPO, W-I-P-O, which stands for the World Intellectual Property Organization, and that is in Geneva, and it is a United Nations agency. The other big one is in Minneapolis in the United States, and that is called the National Arbitration Forum. Then there is the Asian grouping of bodies that look after cases of this sort, and you will find that on the internet under the name Asian Domain Name Dispute Resolution Center, quite easy to find. And there is another body, the Czech Arbitration Court, that do in particular some arbitrations in domain name fields in Europe. So it's important to remember there are those bodies there that are there to help you. They will give you advice. They all have websites. Their websites contain a lot of information for you about domain name cases. So the advantage of this arbitration process is that it's quick. It only takes at the outside a couple of months instead of years in litigation in the courts of most countries. So it's economical, it's quick, it is non-legalistic, it's fairly straightforward compared with many areas of the law. but you will need help in bringing your claim. So it is important that you contact WIPO or the National Arbitration Forum or the Asian body or the Czech Arbitration Court. I have myself a website that deals with domain names, and the purpose of this website is to keep people up to date with cases that have been decided that might be similar to your case. So it's a website devoted to information. It's devoted to setting out details of cases that have come before your case. So you'll be able to use them as an indication of what has to be proved and whether you are likely to win your case or not. This website of mine is www.domaintimes.info. So that's DOMAINTIMES, all one word, domaintimes.info, INFO. So it's www.domaintimes.info, and you'll find a lot of information on that website about domain names, about interesting cases that have come before your case, some news and events about the world of domain names, and I think you might find that quite useful. So that is an outline of the process involved, and I hope you will get in touch if you need any further information. Use that website and you will be able to contact me if you need any further information about this interesting field. All of the cases, by the way, are done online. There are no court hearings as there are in normal court proceedings or litigation. It is all done online and, as we say, on the papers. So the documents are sent to the arbitrators. You can have a case decided, if you want, by one arbitrator, or either side may ask for 3 arbitrators. If you want 3 arbitrators, you can nominate or suggest someone to be appointed for your side. The other party will nominate or recommend someone to be their nominee, and then the provider of arbitration services, WIPO or one of the others that I mentioned before, they will appoint the 3rd member of the panel of 3. So I think I can say to you that this arbitration process is worthwhile. It clearly works. There are now over 35,000 cases that have been decided under this process, which is a lot, and a lot of learning and knowledge has been acquired as a result of that. So the information is all there if you use those sources and if you want to take action to have a domain name transferred to you. So it has been a pleasure talking with you about this, and I hope you have found it interesting. I hope you will get in touch if you want any further information. So thank you very much indeed.